Hello, everyone. Thank you so much for joining me today. I am going to answer some questions that people have sent to me. These are the most frequently asked questions, and I will continue to answer questions. So please send your questions to me in the comments, direct messages, and I will try to answer your questions every week. Okay, first question that I get most frequently is regarding scholarly articles. If you reviewed previous blogs of mine, videos, you will know that um, to have a scholarly article qualify for the EB-1A criteria, the article must be technical in nature, not for the general public. It needs to be written for other technical people. Um, so that's the definition of a scholarly article. But the question was, do you need to be the first author? The answer is no, you do not. As long as your name is on the article, um, and again, it qualifies as a scholarly article under the EB-1A criteria, then um, that should work. Okay. Second, most frequently asked question is regarding premium processing. I would say every single consultation I do, people ask, should I do premium? Okay, so here are the pros or cons, pros and cons. And maybe the only pro is that you get an answer within 2 weeks. So an answer doesn't mean an approval, it's just a response from the Immigration Service. It could be an RFE, maybe annoyed, maybe an approval. But that's really the benefit of premium processing. And people who already have a priority date that's current under the EB-1A category, it may be worth um, filing under premium processing. There's a hefty filing fee, but if your EB-1A is approved, then you can apply for your AOS or I-45 really the next day as long as your priority date is current. Um, but here are the downsides of filing with premium. One, as I mentioned, it's very expensive. Second, there is a very high um, rate of RFEs if you file with premium. I would significantly higher, enough of a chance of an RFE that I do recommend filing with regular processing if you can. Your chances of an approval are greater. Okay, third, most frequently asked question is how do I qualify for the compensation criteria under the EB-1A? So compensation means that you have to command or you earn a high remuneration compared to others in your field. So there is no answer really. I mean, the Immigration Service does not give us a number like this. If you meet this, you meet it. You qualify. So, I mean, that's great because there's flexibility. So, as long as you can convince an immigration service officer that your compensation is higher than most others in your field, you should be able to meet that criterion. Um, but you do have to compare apples to apples. So, if you're using your base wage and you want to compare your base wage and say that it's higher than the base wage earned by others in the field, then you have to compare it to data that uses just base wages. So it's apples to apples. Or you can take your total comp if your total comp is better for you, and you can compare that to others, but you have to compare it to the total comp. So you can't compare your total compensation, which includes bonuses or stocks, to a data, you know, survey that only uses base wage. So there you go. As long as you can make a credible argument, you're using legitimate um, data to compare your wage to, you can create an argument that you meet the compensation criteria. Okay, so the last question I'll answer today is what happens if you apply for the EB-1A and it's ultimately rejected, denied? So you have several options, but the question I get most frequently is, does this impact your EB2 petition that was approved? And the answer is no, it does not. I mean, the good thing about immigrant visa petitions is you can have multiple petitions filed for you, or you can self petition. You can have multiple approved I-140s. But to answer the question directly, if you have an EB2 um, that was approved, no matter when, and then you later file for an EB-1A that gets denied, that doesn't impact your EB2 at all. One thing to think about, though, is your work visa that you're under. So if you're on an H-1B and you have applied for your EB-1A and it was denied, that won't impact your H-1B, because an H-1B is a dual intent visa. The only thing to think about is if you're not on an H-1B, you're on a student visa, a visitor visa, and you apply and it's denied, that may impact you in the future because you should not have been applying for a green card. But that's something you should talk to your immigration attorney about. Anyway, so that's it for today. Please send me direct messages, write a comment with your questions, and I'd love to help answer them. Have a good day. Bye.